ma'am, I'd like to reserve 5 minutes of rebuttal time. Now, Your Honor, this case involves the reimbursement rights between primary and excess insurers under Florida law. The facts are pretty brief, but I think they drive the conclusions in this case. USF&G and Essex issued separate policies to a mutual insured, the Republican Party of Florida. There was a tower of insurance, $10 million. USF&G was the first $6 million. Essex was the next $4 million. Now, there's an insurer that's not here, Federal Insurance Company, that's relevant as well. Federal issued a $10 million policy to the Republican National Committee, and as well as a $1 million policy to the Bush-Cheney 2004 campaign. And I will say that this case is a little long in the tooth, and the motto, Judge, that we talked about just a moment ago is probably fitting in this case. But in any event, on the morning of the 2004 presidential election, there's a terrible accident. The three Republican entities are all sued, and there's a settlement that the three insurers, USF&G and Essex and Federal, mutually fund for $9 million. USF&G pays $6 million, Essex pays $1 million, Federal pays $2 million. They all reserve rights against each other. At USF&G and Essex file separate and independent claims in a consolidated action against Federal counterclaims. Just before trial, USF&G settles with Federal for $600,000 or 10% of what USF&G ultimately are paid to the underlying tort settlement. Essex chose not to settle, went to trial and lost, and while on appeal, settled with Federal for a sum that they have yet to disclose, and then filed an equitable contribution and subrogation claim against USF&G in the trial court. Now, there are a couple facts that, like I said, I think really drive this court's analysis. It is undisputed by Essex that the USF&G claim and the Essex claim against Federal were separate and independent. It's also undisputed that there's nothing that the USF&G settlement with Federal did that in any way harmed or infringed upon Essex's right. It's also undisputed that there's nothing about that settlement that limited or hindered in any way Federal's capacity to make Essex whole. Okay? Separate and independent claims, ability to be made whole. We decided to settle. They decided to go to trial. They lost. Now they want to take our money. It's really just that simple.
Well, now they asked for a set-off from
which was denied.
Well, and told to take that up with USF&G. So they weren't made whole in that respect.
Well,
and they were told essentially to collect that money from you.
Well, they asked for a set-off. In other words, they asked essentially to take our money on the front end. The trial judge denied that, said pursue your equitable contribution and subrogation claims. And then it just went forward. And then what's crazy about the case is the trial judge ended up ruling on a theory of legal or contractual subrogation that, first of all, they expressly rejected, but wasn't even pled in the case. So now when we talk about the made whole doctrine, I think the first thing we've got to figure out is, were these claims separate and independent? And as I said, the facts I think will drive the conclusion here. And it is undisputed that these claims were viewed as separate and independent. And they can't rewrite history at this point. Now,
if they get the $600,000 and they've settled with Federal for $2 million, your position would be that, gosh, they put $2 million on the table to sell the case. Now they're getting 2.6. They made money.
Well, Your Honor, that's one of the very real problems in their case, is that they refused to disclose to us what their deal with Federal was.
Well, that's what.
And so I don't understand how they couldn't be made. I mean, we don't know if they haven't been made whole.
It's been a while since I've practiced law in a private firm, but there's a 3-page agreement that says among the three companies that we agree to settle these claims for $9 million. We're going to pony up this money, 621, I think it was. And then it says, and this is all it says, is that we agree to litigate among ourselves how to settle settlement proceeds should have been allocated among the policies, including but not limited to the policies which apply to the settlement of the underlying litigation, and in what priority said policies apply. That's all it says. So it sounds to me like the three companies are litigating under this agreement, but what are the ground rules? And I don't know what the ground rules are, and I don't see any case law that specifically says how this is supposed to play out.
Well, you're exactly right.
Am I missing something?
I don't think you're missing anything. I think that there aren't any details there. So the question is, what was the position of the parties as they were litigating these equitable contribution and subrogation claims? And that's why I said, frankly, the moment that Essex's representative in the deposition said, on behalf of Essex, we agree that these claims are separate and independent, in my mind, this claim was over. Because they're either separate and independent or they're not. And if they're separate and independent, they don't have a right to be concerned about what we do. And of course, we don't have a right to be concerned with what they do.
When you say separate and independent, and it seems to me to say that you two get to fight it out, and whatever it's sort of like you get to eat what you kill. You got $600,000, so you get to keep that. They don't get a part of that. You litigated it, and you got that, and you get to put it back in your pocket because you put out $6 million, you got $600,000 back. They likewise get to go out and eat what they kill. Well, they shot and they missed, and they tried to get $2 million from federal, and they lost. So isn't that sort of I hate to say eat what you kill, but that's sort of what's going on here, isn't it?
Well, it's exactly what's going on. It's exactly what they said was going on.
They don't get to snatch the bird. I see a bird flying away with the prey in its talons, and they want to snatch it away from you, is sort of the analogy.
Well, they want a chance to go hit a home run against federal.
Okay.
And if they lose, use our money as a backstop, even though they're taking the position the whole time that the claims are separate and independent and we can do whatever we want. I mean, they're 30B6 representative in the record, and I would suggest that pages 11014 to 11020, it's where the testimony really was, I think, most on point for this discussion. Their representative said the claims were separate and independent. We had nothing to do and had no right to infringe upon, object to, or somehow control the settlement that USF&G had with federal. So they can't go back and rewrite history. Now, Your Honor, one thing that I think is just a fundamental problem with this case is that they specifically took the position in the record on page 10939, this is a quote, that Essex has never claimed to be in privity with USF&G, nor suggested that USF&G is bound by the language of Essex's policy. So that's their position. So you got the trial court coming back when they can't even put forth the equitable principle that they're relying upon. He's looking for something to rule in their favor. And he says, well, the policy mandates and the language of the policy requires that USF&G pay this money to federal. Well, that's a legal or contractual subrogation claim.
Well, let me ask you, it seems like the trial court might have seen what you're talking about, tried to cover itself with that footnote where it essentially said, nothing in this order means that there aren't other bases on which Essex could collect this judgment from your client. What if the court had just simply said, motion for summary judgment granted? I don't necessarily think. They didn't exactly analyze this on a theory of equitable subrogation, but certainly the court implied that might be a legitimate basis as well.
Well, what the court implied was that there are other grounds that might be out there, but the court's not going to address them. And, Your Honor, there's a very sort of practical approach here, is that the lawyers drafted the order, and the lawyer that the judge tells is going to win the deal gets to draft the order. So they drafted the order, and they're the ones that put that language in there because they knew what was happening was not right, that he was ruling on a theory of contractual subrogation. He was ruling that the policy language was binding upon USF&G when they took the express position that it was not. Now, Your Honor,
just so I understand it, I've got the provision here. The contract is between the Republican Party of Florida and Essex.
The policy.
Your client is not a party to that policy.
Exactly right.
So if the Republican Party of Florida were to get $600,000 for some reason, they would have to turn it over, perhaps under the subrogation provision. But you're not. Am I?
No,
in
Your
other
Honor.
words, if they pay money on behalf of their insured, the Republican Party of Florida, say $2 million, and somehow the Republican Party of Florida gets some funds from some other insurance company, the Republican Party of Florida doesn't get to keep it under the subrogation.
Well, it's a third-party policy, so the insured's not going to get a recovery from somebody else. But, this is really like the made-whole doctrine argument that we made in our case. There's the Morgan case, there's the Martin case, and there's the Graff case. And they all deal with a situation where an insured tries to negotiate away the insurer's right of reimbursement under the policy. And what this court has said 3 different times, and the Graff case is probably the best case for this principle. What this court has said is that if the tortfeasor that the insured is going to pursue has the capacity to make both the insured and the insurer whole, we are not going to allow the insured to negotiate away. You essentially use the insurer's right of reimbursement as a negotiating tool, and that is exactly what they are trying to do here. They're saying they're stepping into our insured shoes and that they somehow get to have their cake and eat it too. And on rebuttal, I will talk about what really awful public policy Essex position really stands for. But I'll reserve the rest of my time. Thank you.
Thank you, counsel.
May it please the Court, Megan Logan on behalf of the appellee, Essex Insurance Company. I'd like to begin by addressing the myth that Essex was granted summary judgment on an unpled theory of contractual or legal subrogation. There's nothing in the record to support this conclusion. In its motion for summary judgment, Essex relied on 4 contractual provisions of its policy with the Republican Party of Florida that stood for the premise that Essex was an excess insurance carrier, the last to pay, and in our mind, the first to recover, should there be a recovery. We used those 4 provisions within the motion to show the court that Essex was in fact excess and entitled to first recovery should there be any. The court adopted that reasoning in concluding that the language of the policy mandated that Essex recover the $600,000 that USF&G had recovered from federal. As to the footnote, first I'd like to point out that who drafted the order and all of those things relating to the footnote is nowhere in the record. But even assuming the court were to consider that, Essex raised 2 theories, equitable subrogation and contribution. In my mind, the court addressed subrogation in its order in concluding that Essex was entitled to the entire $600,000 as a result of its $1 million payment. But I think that also left open avenues that, even if the language of the policy provided that Essex should in fact recover, it was also allowing the parties to, argue the other principles that were raised in the motions, public policy, things like that. It wasn't simply limiting them to the language of the policy.
Well, let me ask you this: if one of the bases upon which the trial court ruled that you're entitled to the $600,000 was an equitable one, why wouldn't they be entitled to the costs associated with recovering that?
I think first off, they relied upon the subrogation provision from Essex's policy to which they're not a party for recovery of those expenses. And they, in essence, can't have their cake and eat it too and argue that it's not, we can't rely on our policy language, but they can in obtaining those expenses. Second, Your Honor, we made the argument below that essentially the expenses in this case would consist of cost and attorney's fees, at least that's what they claimed, and that attorney's fees in Florida are only recoverable by contract or statute, so that equity would not provide a basis for recovery of attorney's fees, which were the expenses they were seeking.
So why would a company in USF&G's position ever pursue compensation here like they did? If they're going to come out $200,000 of attorney's fees and costs, and they get a big hunk of money, they just got to turn over to you and they're out. I don't understand why they would do that.
I think they would pursue it, one, under the hopes that they would recover more than the excess has paid so that they could recover or replenish the primary policy, but only after satisfying the excess carrier. And second, and I think this goes to what I think is kind of a poor notion in this case, is that the claims were separate and independent, and that somehow drives the ruling in this case and the entire outcome of this case. And I think what's been overlooked is that Essex, as an excess insurer, didn't have to have a claim against federal. To the contrary, I think USF&G, as the primary carrier, could have asserted a claim, and only it asserted a claim, so that you wouldn't even have a competing interest of whether claims were separate and independent. It could have asserted its own claim, but if in fact it only recovered amounts that were paid by the excess carrier and didn't get back to its primary limits, it ran the risk that the excess carrier would come after those amounts if it did not include the excess carrier in its settlement discussions or somehow account for their interests.
Did I misunderstand the record that the reason that Essex was unsuccessful in its suit against Federal was a finding that Federal's insured wasn't responsible at all here?
The issue, as I recall it from that case, Your Honor, was whether Kevin Hampton, the driver of the vehicle that caused the accident, was a volunteer under the policies issued by Federal. And so it ultimately turned on the analysis of what was a volunteer and that policy language, and the court concluded that he was not, in fact, a volunteer.
So at the end of the day, Federal contributed to the settlement that it ultimately was shown it kind of made the worst bet of all here. It threw money in, and it turns out it didn't have a legal obligation to.
That's correct, Your Honor. And to address...
So I guess to me, that's where their argument about these things being separate and distinct. You're, if I understand correctly, your client is the excess insurer of the party, literally the party, that was found to be, or I guess, was it ever found to be responsible?
It was not. I think both USF&G and Essex acknowledged that that was their insured and that they were responsible. And the sole question which made them co-plaintiffs was whether or not Federal and its entities, BCO4 and the RNC, had coverage for that same accident. But Your Honor is correct. I mean, they ultimately made the worst gamble of all and paid in $2 million. One point I'd also like to correct is that
not only $2 million, but the additional $600,000 plus whatever they'd settled with you.
Correct, and that's what I was getting at, is that I think a misnomer in this case has been that they lost additional funds to Essex in the settlement. Although the amount of the settlement was confidential, it has been revealed, and it's in the record, that Essex paid Federal, not vice versa. So Essex lost money to Federal again, so paid out an additional sum to Federal versus recouping anything from Federal, so that there's no windfall or this made whole doctrine based on.
That's, I mean, I guess the argument would be that the fact that you paid out is because you sued somebody that wasn't responsible for this accident. They
Correct.
were, in their view, smart enough to recognize that they may not be responsible. We'll take what they'll give us and go on our way.
So what was the amount? Where is it in the record? Because I couldn't find it.
The amount is not in the record, Your Honor. During the hearing on the summary judgment motion, this argument was raised, and it was somehow suggested that Essex would be receiving a windfall because of money it had received from Federal, and now it was seeking the return of the $600,000 from USF&G. And I don't have a specific page number, but it is there toward the end of the transcript where it says, where I clearly disclosed to the judge that Essex had in fact paid Federal to resolve that lawsuit.
Again, I'm sorry I'm being dense this morning, but I guess I don't understand how you would get the entire, even if you prevail here, how you would be entitled to the entire $600,000. I mean, this is money that you say you're entitled to from a subjugation theory in some way. I mean, how doesn't that necessarily require you just to get the net? I mean, how do you get the gross and they're out the cost of procuring money, in theory, for you?
Again, I think that is the relationship and the fundamental principle of Florida law, that excess insurers do not pay until primary carriers have exhausted their limits. And that's what occurred in this case, Your Honor. Essex paid $1 million into the underlying settlement and agreed with USF&G to recover against Federal. When USF&G recovered against Federal, and Essex did not, but USF&G did not consider the excess insurer's interest, Essex sought return of the full $600,000, which is less than the $1 million we paid into the settlement, on the belief that that money should go to the excess carrier as opposed to serving to replenish primary policy limits. And inherent in that, again, is the relationship between primary and excess insurers, and the fact that primary insurers, they calculate their risk and are the first to pay in any instance. And I think that goes back to what we discussed as far as both USF&G and Essex never challenging that their insureds were at fault or seeking any kind of declaration on that. USF&G is the primary insurer for the party, accepted that risk and paid into the policy, so that if anything was going to be paid back, it should have been paid back to the excess carrier and not the primary limits, as the primary policy contracted for that it would be the first up in the event of an incident that triggered coverage. I'd like to address the Reliance case, which was relied upon extensively by counsel both at the trial court and on appeal.
Let me ask you one other question before you do that. Did USF&G, under that theory, have an obligation to pursue federal on your behalf?
I don't think they did. I don't think they had an obligation to do so. And again, I think it was a decision amongst the carriers, as evidenced by that agreement, that they would do so. And I agree with Judge Makar. I mean, I think the rules and the regulations of how it was to be done are largely unwritten. But no, in answer to Your Honor's question, I don't think they had an obligation to do so. But the fact that they did so and didn't consider our interest in resolving the case is what has led us here to the current situation. In addressing Reliance, USF&G has relied on this case heavily, that should somehow govern the court's result both below and here on appeal. And Reliance not only is factually distinguishable, it's legally distinguishable. First off, we talked about this at the summary judgment hearing, but what we have here is a replenishment or a recoupment issue, not a payment issue. And Reliance speaks to payment. Reliance held that if a primary insurance carrier settles or pays its insured less than the full primary policy limits, the excess insurer's coverage can still be triggered even though the primary carrier has not paid out in full. And here, that principle is not what we have. We had a primary carrier who paid completely and exhausted their $6 million limits only to seek recovery and obtain recovery of $600,000 from federal that we contend should be used to satisfy the excess layer. And Reliance doesn't speak to that. It's a payment case, not a recoupment case. No case speaks to that. I think the closest we come is the Amerishore case that's been cited by Essex in its answer brief, which at least is a replenishment case or a recoupment case, and talks about attributing money from third parties and what layer of insurance coverage it should be attributed to. I would also venture to say that Reliance was just wrongly decided. Reliance, a 2001 case from the 3rd DCA, in the 15 years it's been law, has only been cited by 3 courts, 2 of which have disagreed with it, 1 out of Louisiana, which has agreed with it, but again, dealing with insureds, not this contribution or determination among insurers as to who is entitled to precedent or priority in coverage.
Tell me this, if you'd sued federal and you got $1.2 million from federal, so that you're not out any money now, you actually made money, you're up by $200,000. Does that go to USF&G, or does that you just get to keep that?
I think it does. I think the extent that we paid into the underlying settlement was $1 million. The only amount we could recoup and be made whole, to the extent that principle would exist in this case, would be $1 million, and any amount beyond that would go to the primary insurer.
Okay, and your authority for that is, well, that's the way it should work?
And that, correct. I mean, that and just recognizing the excess primary relationship and that's how it should work in theory. Moving on to the made whole doctrine, counsel has cited that repeatedly in this case. It's our position that doctrine is wholly inapplicable in this case, as it involves an insured and an insurer, and again, not the competing interest among insurers that we have in the present case. Counsel for USF&G has cited no case to where the made whole doctrine is applicable to a situation such as the present case. involving multiple insurers. All of those cases involved insureds and serve to protect the insured. That's the essential theory behind it, which is not applicable here because the insured was protected by both carriers and is out, leaving the insurers to battle amongst themselves. If and when that principle ever did apply, we contend it would further support Essex's position, since the theory in that case is that you protect the insured, and in this case, as USF&G has pointed out, Essex has alleged that we are standing in the shoes of the insured, so it would serve to protect Essex and not USF&G. On rebuttal, I anticipate Mr. McMickle will talk about public policy and tell you again that this should be frowned upon because a primary insurer could never settle and obtain its piece with fear of the excess insurer coming in to take their funds. And using Judge Makar's example of a bird with prey in its talons, that the excess carrier would swoop in and take that. And again, without law guiding us as to how that should be resolved, I would submit that that is the risk a primary carrier runs when they do not account for the excess insurer's position or the fact that they have not yet been paid back in their and settle the case without considering that obligation. Thank you, Your Honors.
Thank you, Counsel.
Your Honors, Essex just said that why we are here today is because USF&G was somehow obligated to consult with them and get their approval of the settlement that is directly in conflict with their position at the trial court. On the record on page 11020, I asked their representative who bound the corporation, could Essex have extinguished USF&G's claim without USF&G's consent? The answer from Essex at trial was USF&G had its own independent claim that it was free to negotiate or litigate. They just said the reason we're here is something in direct conflict with that position. Reversal is warranted. The trial court clearly ruled upon a contractual theory that was not pled. Under Georgia law, reversal is required. Florida law,
Let me ask you this quickly, because I know your time's running out. I still am struggling with what the law is we're supposed to be applying, what principles we're supposed to be applying here. If the idea is to equitably reimburse those who have put the money on the table at the outset to settle it, how's the court to do that? Because there's a component here, a piece of the puzzle, the undisclosed settlement, to really know how to do that. So I'm just looking for some guidance on what principle of law, other than, well, this is how it works. Because frankly, is this the way it works in these cases? Is this how the industry handles it? We all throw money in a pool and then we fight it out for 12 years? I mean, this is an unusual case.
There are situations where insurers pay, settle the tort claims, and then dispute between themselves. That does happen. Now, it's funny, my client asked me when we were talking about this hearing, they said, what's the basic equitable principle in play? And I said, I don't know. They don't have one. That's the reason that the trial court did what the trial court did. And I didn't hear her say in any lucid manner what the equitable principle was. I mean, I suppose that's the reason for your question, Your Honor. Now, Your Honor, she admitted that there was nothing in the record about the content of the settlement between Essex and Federal. What she said is, well, I told the judge it was all good and that we weren't made whole. That's not evidence. And that is, I think, a real problem for their case. Now, Judge, with regard to your question about these fees, I mean, we shouldn't have to pay the $600,000, and I think that's pretty clear. But to the extent you rule against us on that, fundamental fairness says that they have to pay the cost associated with chasing that money. Now, the only argument they made on appeal on that issue was that we didn't raise equitable issues at the trial court. Simply false. If the court will look.
Let me ask a question before you get there, and maybe this goes to Judge Makar's issue with the contract not really laying out the ground rules. It seems to me that at some level there needed to be a determination. You got two people, potential insureds, I guess, that are responsible for something, and you have a bunch of people throwing money into the pot. When it's determined that one of the people, this volunteer, or that company isn't really responsible, then the entire $9 million of the settlement is attributable to you and the excess insurer. And so it seems like if you do the apportionment, and I know we're not purely an apportionment, it seems like that would be how this would, in concept, work out. I mean, isn't that the idea? By throwing the money in the pot, we'll figure out later what the percentage or who's responsible for what. Somebody paid more, somebody paid less. But in this case, it turns out that your side versus the federal side was the one who should have paid a lot more, and they should have paid maybe nothing.
We paid everything we had. We paid our full $6 million. There was complete exhaustion on the front end. The question then becomes, what do you do with the reimbursement rights? And they're either separate and independent or they're not. If they're not separate, or excuse me, if they are separate and independent, which was their position, they can't come back and take our money now. That's simply inherently unfair.
And I'm sorry, I cut you off. You can finish your response on the equitable argument you made below, I guess.
And Your Honor, they said we didn't raise the issue of equity with regard to our fees. That was their only argument in their answer brief. And it's just wrong. In the two different places in the record, record at 10826 and 10810, we had specific sections of briefs with the trial court on this exact issue. And the headings for the section where Essex's position violate basic principles of equity. So it's just not correct to say that we didn't raise an equitable argument there. Thank you, Your Honor.
All right. Thank you, counsel. All right. That concludes our docket for today, so we will be in recess till tomorrow morning. Thank you.